All right, good morning, everybody. Thanks for hopping on with us today for another great COVID-19 webinar. So this morning, Chris Dutton from Porter Wright is going to talk about the legal ramifications of building during a pandemic. And you might have been on another webinar or two with Chris, but I'll just give a quick intro and then I'll let him start. So Chris Dutton is a senior associate in the Porter Wright's litigation department, focusing on construction and commercial business litigation. Chris has been involved in the successful resolution of claims in state and federal courts in both Ohio and Kentucky, as well as multiple private arbitrations and mediations. And Chris also has a pre-law background in the construction industry, so that makes him very relatable to this topic today. So I will go ahead and turn it over to Chris.
Thanks, Jen. Hi, everybody. Thanks for being here. Obviously, we're here to talk about COVID-19 and construction. And I've actually also been teaching in the College of Engineering a class called Construction Documents, Quality Control and Project Delivery Systems for about 13 years now. In between ACI, client presentations in my class, I've given a lot of construction presentations over the last decade plus. And I speak with a lot more certainty than I normally feel, or than I normally speak with more certainty than I do now. We're off the edge of the map here on a lot of this stuff. Obviously, as you know, I've spent a lot of time doing my own research, reviewing the research of others, to not only come up with this presentation, but to counsel my own clients on some of these issues. And we're just going to dive on into it here today. If anybody on the line has any questions, you can feel free to shout them out. I don't know that I can see the chat. Jen, if you're able to see the chat and somebody chats in a question, just shout it out and let me know if anybody's got anything on their mind that they want to talk about. Otherwise, figure out how to scroll here during, there we go, perhaps. Well, oh, it's because I'm at the end. Sorry, everybody. I planned on doing this on my desktop computer, as you might have figured out by now, and had to resort to plan B on a laptop here. So this is what we're going to talk about today. We spend much of our time on force majeure because it's the question that seems to be not only on the construction industry's mind, but as we're going to look at here, on the world's mind. More than any of the other topics I've looked at, force majeure as a means of getting out of or changing a contract is a lot of what business generally is talking about, not just construction. A lot of information on that. And I'll talk to you in a second here on how I approached it, and how I hope that you all can approach it as you go forward based on what I'm seeing here. We're going to talk about claim requirements, human resources and safeties, insurance, and then a few other contract provisions that I think it's important to keep in mind. But getting right into it here, a lot of content here to get through in an hour that I hope is useful to you. So force majeure, what is it? Black's Law Dictionary, which is to lawyers what Webster's is to the rest of the speaking population. Black's Law Dictionary is what we go to for definitions, and it defines force majeure as an event or effect that can be neither anticipated nor controlled. Terms include both acts of nature and acts of people. Black's doesn't actually say acts of God, even though a lot of people say force majeure and act of God are interchangeable. In a lot of ways, that's true. Black's didn't go there, but the gist of it, I think, is captured in that definition. Literally, force majeure is French for a superior force. So the coronavirus is novel, but in the construction industry, force majeure isn't. I've been dealing with force majeure as a construction practitioner, both, as a project manager, estimator, and as an attorney for over 15 years now. We've seen force majeure before in the form of bad weather or other types of construction disruptions. But we haven't seen it like this before. We haven't seen it in a worldwide pandemic type of situation, which causes all of us, I think, to reflect and analyze force majeure through a different lens than we have previously. But at the end of the day, force majeure is often going to result into project delays, if not contract termination, that costs money, and that often results in claims. When I say claims, I don't necessarily mean the type of claims that you lawyer up and go to court or arbitration over. If you're just negotiating a change order for a time extension or for additional money to be paid to you because of a project delay or because of a termination, your construction contract defines that as a claim. It's just an unresolved dispute between you and the other party on the other side of that contract, whether it's a contractor, a subcontractor, the owner. If there's a dispute over how much money is getting paid or isn't getting paid, that's how I'm defining claim. That's how your contract generally defines claims. So here's a headline from the Wall Street Journal. Coronavirus contract disputes start hitting the courts. Companies invoke a little used escape hatch known as force majeure to get out of legal obligations. Little used made me laugh because it's not that little used in the construction industry. Apparently the rest of the world is figuring out this is a thing now. We've seen it before. We've dealt with it before. And to some extent, we know how courts are going to handle it in the course of a construction dispute. We don't necessarily know how it's going to come out in the courts as a pandemic, however, versus, a bad weather event or something like that. This is a quote from that article. The coronavirus is putting a spotlight on the force majeure clause and testing the sanctity of contracts, a cornerstone of market economy like no other event, lawyers say. A wave of litigation is expected in the coming months. Now, I don't know what lawyer said that, so I went and took a look myself just for fun. And this is what I came up with. I had done some COVID-19 / force majeure related searches before May 8th, and I'll talk about those in a little bit. But I started preparing for this presentation with gusto on May 8th. LexisNexis is a database that lawyers use for research. Back in the day, we used, shelves and shelves of books. Now everything's online. So all of the court opinions published in the United States of America are logged into LexisNexis. There are a few competing products, much like there's Google and there's Yahoo and there's Bing. There's LexisNexis and there's a few other products. My firm uses LexisNexis. So just for my own curiosity's sake, on May 8th, I put COVID-19 into the LexisNexis search engine just to see how many hits I would get. I got 2,866, as you can see there. Most of those, honestly, are not COVID-19 driven lawsuits. Most of those references to COVID-19 are just footnotes. For example, one that I saw, I didn't obviously read all 2,866 cases, but I skimmed through them. And what I saw a lot of is a footnote that said the hearing on this particular decision was held via teleconference rather than in open court due to COVID-19. So the word COVID-19 is a hit. Didn't necessarily mean it was a COVID-19 case, but still some of that was. And I think that the results of this of these two searches show the growth in the amount of times this is coming up in court. So when I Googled it on May 8th, just the phrase COVID-19, I got 2,800 plus results. Less than 2 weeks later, on May 25th, I LexisNexis'd it, rather, not Googled it again, and got 4,089. So, roughly, a third or 66% growth or 33% growth in a short amount of time. I guess that's actually about 50% growth. When I Googled COVID-19 in construction, both of those words have to show up. I went from 157 to 222. COVID-19 and construction and contract, meaning all three words have to show up. I went from 88 to 120. And for COVID-19, construction and contractor, 23 to 35. Point is, these cases are growing, and they're going to continue growing. So force majeure, the three words that get used a lot in force majeure litigation are unforeseeable, unavoidable, and impossible. We couldn't have foreseen this coming. Once we knew it was coming and once it arrived, we couldn't avoid it, and it rendered our ability to perform impossible. And of those three words, impossible is kind of the one that is construed the most strictly by courts. Is a pandemic completely unforeseeable? To some extent, no. We didn't expect it, but you knew it was at least a potential thing. Courts are a little more relaxed on the unforeseeable and the unavoidable part, but the impossible part gets tricky. Just because something is rendered really, really hard and a lot more difficult than you thought it was going to be when you signed that contract. That doesn't make it impossible. The case that comes to mind pre-COVID-19, there was a case out of New York City where there was a project in the city that was largely composed of components that were engineered and built off-site that had to be hauled to the site and assembled. And that off-site location was somewhere in New Jersey. And during the course of the project, whatever tunnel or bridge that was the most obvious way to get materials from Jersey to New York was closed. And they wound up having to hire a barge or some ridiculous means of getting it across, and it was ridiculously expensive. And they tried to argue impossibility, and the court said, no, that's not impossible. You can still perform this contract, and you may lose the company over it, but we're not going to say this is a force majeure type of situation, because losing that bridge doesn't make it impossible. So impossible is a big hurdle. Keep that in mind as we go forward. A few of the cases that we've seen pop up so far where plaintiffs have alleged that they can't perform because of force majeure, because of the COVID-19 situation. I'm going to talk about a few of them just to show you what the courts are looking at and what lawyers are thinking about as they go forward. First one is the Pacific Collective versus ExxonMobil Corp. This is a case where Pacific was a developer that was just buying land from Exxon, and it was a time is of the essence clause. We need to close this land deal by X date. There happened to be a force majeure clause in the contract. COVID-19 comes down the pike, and all of a sudden the buyer says, we need more time to close. We can't close on time. We don't want you to sell the land, Exxon. We want you to hold it for us. And we want you to perform under the contract, because under this force majeure clause, we have the opportunity to expect you to do that. And Exxon doesn't want to do that. They've got another buyer they want to sell, and that is now being litigated. Part of the argument from the plaintiffs is if we close right now, it would break the law. There are all these social distancing laws that we have to observe. If we close right now, we couldn't develop the property as we planned, blah, blah, blah. Important example of this particular lawsuit, or the point of this particular lawsuit, the other ones that we're going to look at here, is that their force majeure clause rather, didn't include pandemics. I'm going to show you what that looks like in construction here in a minute. But it is important for your force majeure clauses to be as specific as possible. More on that here in a second. I want to look at these other cases here, and then we'll break it down for you. There's one in the Southern District of New York where a franchisee was buying an amusement park franchise from a franchisor. Now they want out of the deal because they say, we can't operate a amusement park during social distancing. There's no point in this contract anymore. Again, there was a force majeure clause without pandemics listed in the contract, and the franchisor defendant is arguing that that force majeure clause isn't good enough because the clause was too broad. And in another one, it's just a regular landlord-tenant dispute down in Florida. A tenant saying, I can't pay my rent on a big commercial property because I don't have any revenue anymore because of COVID-19, and I'm relying on the force majeure clause to relieve me of my obligation to pay rent. Again, pandemics are not specifically mentioned in the force majeure clause, and as we're going to see, that means something. And I had my very own version of this case. There was a client of mine is a real estate agent, and when one of her deals goes bad, she often refers her seller or buyer, depending on the case, to me. And this was a case where just a husband and wife were selling their property. It was a nice, expensive property, but still just a residential property, not terribly expensive when you compare it to a commercial project that's millions of dollars, but still a nice property. They had a deal to sell it. Everything, all the contingencies were met, financing, appraisal, everything was good to go. Then COVID-19 hits the fan. The buyer gets cold feet. The buyer is afraid that she's going to lose her job, hasn't lost it yet, but is afraid that she's going to lose it, and pulls the plug on the deal, refuses to close. That's still a breach of contract. There's nothing in that contract that says you get to breach just because you're having employment concerns. If she'd have lost her job for some unrelated reason or reason unrelated to COVID-19, you still have to continue performance. And maybe you choose to breach, you know, that's your business. If breaching a real estate deal and being liable for those damages is more attractive to you than defaulting on a mortgage, I get that, but you still are bound by the contract. So there, and again, she tried to argue that her performance was impossible. I can't perform, I can't close because of COVID-19. And that's just not true. In my office, there's a title department right down the hall from me that's doing closings every day. I know you can close. It may be hard, but it's not impossible. This is from an Ohio case where a court said is weighing in on what it expects to see if it's going to enforce a force majeure clause. The court says force majeure clauses are typically narrowly construed such that the clause will generally only excuse a party's non-performance if the event that caused the party's non-performance is specifically identified. So we're going to take a look at some construction contracts that most of you are probably familiar with that aren't specific. And if you didn't know how narrowly the courts, narrowly construed is a word or as a phrase that courts use all the time when they say, we're not going to enforce this clause unless we absolutely have to. If it's just some general catch-all, it's not happening. We want to see the word pandemic. We want to see the word quarantine. And if we don't, we're probably going to say this isn't the type of risk that you expected when you signed this contract that included this clause, and we're not going to enforce it. So where do I want to be in the hierarchy of possible contracts? Best place that you can be is to look at your contract or to negotiate a new contract that explicitly relates to COVID-19 and other pandemics. A clause that says something like, due to the current pandemic, COVID-19, certain conditions may arise that cause delays or elevation in the project price, and we reserve the right to renegotiate a change order accordingly. You're going to get pushback from an owner or from a contractor on that. I get that. I understand that. And maybe if you want the deal bad enough, that clause doesn't get in. And I understand it's a business and you have to make the best deal you can, which might not include an explicit reference to COVID-19 and the pandemic. But if you can get away with it, you want to, because that is the highest ground that you can be if you need to actually negotiate that change order at some point. The next tier down is just a general force majeure clause. Better than nothing, but not nearly as good as having a specific one that either mentions COVID-19 by name or at least mentions pandemics, quarantines, things like that. The next tier below that, we're getting on lower and squishier ground here, is a contract with a general force majeure, without a general force majeure clause, so no clause. There are alternative arguments that you can make even if you don't have a force majeure clause, and we'll talk about those. But still, your position is getting weaker and weaker as we go here. And then the lowest level is no written contract. So we're going to look at our old friends, the A101 and the A201, as a baseline. And that's how I approached this presentation. You know, before I went and read all the articles that I could find on different aspects of force majeure and its impact on the construction industry, I took the A101 and the A201, which if you don't know, are probably the most widely used, not probably, they are the most widely used construction contract templates in America. And the A101 is just the standard construction agreement between an owner and a contractor for guaranteed maximum price. And the A201 is its companion document with the general conditions in it. And that A201 general conditions document often finds itself attached to not only the general contract, but many of the subcontracts and even the design agreement sometime. So I took these two documents and basically created my own hypothetical. If I had to litigate a force majeure clause on behalf of one of my clients and I was using an unedited version of the A101 and A201, what would I be dealing with? What would my strengths be? What would my weaknesses be? And we're going to go ahead and run that analysis to show you, even if you're not using the A101 and the A201, I'm hopeful that this analysis will help you understand what you're looking for in your own contracts that you're familiar with as you go forward, and ones that you're already performing right now. So where do the A101 and A201 fall within the hierarchy? We're going to talk about both delay and termination. With regard to delay, the A201 references a force majeure type of clause. There's force majeure type of language with regard to delay only. There really isn't with regard to termination. And we're going to take a look at those right now. Again, we're going to talk about both delays and termination. We're going to start with delays. This is the A101's clause. I'm not going to read all of these verbatim. I'm just including them for you so that you can read them offline. Jen can make these slides available to you so that you can read them carefully on your own if you choose to do so. But otherwise, I'm just going to describe what's here to you. The A101 just reverts to the A201. It says, you know, with regard to a delay, go look at the A201 to figure out how to handle it. Now, the A101 references Article 9. Article 9 of the A201 only talks about how payment works. If you have an undisputed receivable, your base contract, your approved change orders, Article 9 just says, you know, you submit your pay application by X date, it gets reviewed by Y date, you get paid by Z date. It doesn't talk about things that haven't been fully negotiated yet or disputes. So the A201, as we're going to see, is helpful, but I wanted you to know that Article 9 the reason we're not going to be looking at Article 9 is because it only talks about payment of things that you've already negotiated. We are going to talk about Article 8.3, though, which talks about delays and time extensions. What 8.3 says, if the contractor is delayed for a series of reasons, then they're entitled to a time extension. And I've highlighted the reasons that bear relevant to COVID-19 and pandemics. And you see them on your screen there. So if the contract is delayed by labor disputes, fire, unusual delays in deliveries, unavoidable casualties, adverse weather conditions, or other causes beyond the contractor's control, or by other causes that the contractor asserts. Now, you saw the quote from Ohio courts that said, we want you to be specific if we're going to enforce your force majeure clause. We want you to name the event that you thought might happen when you negotiated this contract. And what is clearly omitted from the A201, one of the most widely used contract templates in the construction industry, is any reference to pandemics. Now, there are a few useful things here that I would argue if I were representing a client trying to prosecute a force majeure claim with this clause. For example, unusual delays in deliveries is a real concern driven by the virus. You know, contractors are worried that they're not going to be able to get materials as timely as they used to, given the restrictions on movement and on shipping and things like that. So if COVID-19 is part of the reason you can't get materials, you can use this unusual delay in deliveries clause. If you have other issues, though, not related to delivery slowness or broader than delivery slowness, then we're stuck with unavoidable casualties. I'm not even sure what the contract means when it says casualties. I did a word search within the contract template itself to see if casualty was mentioned anywhere else. It's not. I assume by casualties, they just mean losses. So unavoidable losses or other causes beyond the contractor's control or by other causes that the contractor asserts. Those are the types of broad catch-alls that courts don't like. It's better than not having anything to argue at all. It's better than not having a force majeure clause. It's better than not having a written contract, but it's not as good as having a clause that actually says pandemics in it. So looking at these other parts of section 8.3, claims relating to time shall be made in accordance with applicable provisions of Article 15. We're going to look at Article 15. That's the claims procedure. It's important. And section 8.3 does not preclude recovery of damages for delay by either party. That's a cleverly worded phrase. So if you look at just at 8.3.1, it says, hey, if you're delayed for a cause beyond your control, you get extra time. Doesn't guarantee you that you're going to get extra money. And then 8.3.3 kicks in and says, well, we're not saying you can't get extra money, but we're not saying that you can either. You guys can negotiate it, you and your owner or you and your contractor. So 8.3 leaves that door open for you, but it certainly doesn't promise you additional money along with additional time. You are promised additional time. You are not promised additional money. Other clauses that I found relevant and in some cases helpful, 10.4. In an emergency affecting safety of persons or property, the contractor shall act at the contractor's discretion to prevent threatened damage, injury, or loss. Additional compensation or extension of time claimed by the contractor on the account of the emergency shall be determined as provided in, again, Article 15, the claims section, and Article 7. Again, I'm not going to talk about Article 7. Article 9 is about the payment process. Article 7 is about the change order process. Both of those articles assume that a dispute has been resolved. 15 assumes that it hasn't, and it tells you how to handle that dispute. But this emergency clause could be helpful. If you're on a project and you find out suddenly that there might be an infected person or persons, you might choose to remove your crew under this emergency clause and reserve the right to make a demand for extra time or compensation accordingly. So this clause is good to keep in the back of your mind if you are faced with the unfortunate situation of a true emergency. 11.4 is also helpful for contractors. 11.4, the first sentence says, an owner can go ahead and buy an insurance package in order to cover the potential liability of interrupted business. So if this project isn't done on time and business is interrupted, there's an insurance product for that the owner can buy. This last sentence, though, is important. The owner waives all rights of action against the contractor and architect for loss of use of the owner's property due to fire or other hazards, however caused. So if I've got an owner who wants to hold me accountable for business interruption because their project was delayed or terminated because of COVID-19, this can be a powerful clause for me to say, hey, you have already waived your opportunity to come at me for a lost business opportunity pursuant to Section 11.4 of the contract. So now we're going to talk about delays, and delays aren't new in construction, as you all know, and some of this might look familiar to you if you've seen a delayed presentation before. But looking at it through a different lens, I was surprised to see some of the things that I'd never seen before. Just looking at those clauses we just looked at, seeing things I've never seen before. So a recap bears the time. So there's three types of delay in construction: non-excusable, excusable, non-compensable, and excusable, compensable. There are all sorts of fancy legal definitions as to what all those mean, but what it boils down to is this. Non-excusable delay is the contractor's fault. Contractor screwed up, didn't have enough human resources, didn't get material delivered in time, worked inefficiently, whatever the case, it's the contractor's fault. You don't get a pass for that. If it's your fault, you have to make up the time you lost or be in breach. The next is excusable, non-compensable. That's where it's no one's fault. It rained for 40 days and 40 nights. There was a landslide. We didn't know that was coming. It just happened. So that's not the owner's fault. It's not the contractor's fault. It just happened. And it did cause a delay, but we can't put it on anybody's shoulders. And then the last type is the excusable, compensable delay, and that's where it's the owner's fault. Owner didn't get financing in time. Owner didn't get permits in time, whatever the case may be. Construction was delayed because of the owner. So those are the three types of delays to keep in mind. Force majeure claims go in the middle, obviously. A force majeure is an excusable, non-compensable delay, generally. So COVID-19 comes. Is that a force majeure issue? Is an excusable delay? Probably. More on that in a minute here. But let's assume for now it is. COVID-19 is an unforeseeable event. It is an excusable but non-compensable delay. And you hear non-compensable and you think, don't we get more money? Don't we get more time? Do we get both? Do we get neither? Well, the answer, every favorite lawyer answer, is it depends. Depending on the language in the contract, the builder is probably entitled to either a time extension or additional compensation, but not both. So you saw the contract. I think here's the same clause, section 8.3. We've already looked at this already. Section 8.3 automatically entitles you as the builder to more time if the project is delayed for reasons beyond your control. that, you know, everything in law is debatable, but we'll pretend for fun that this is the most rock solid clause, because it's pretty solid. You are entitled to more time if something happens beyond your control. But again, it does not specifically say, and you're not specifically entitled to more money. Now, you can negotiate that if you've got a reasonable owner who recognizes that this is a thing and they want to be fair and they want their project done. You know, you can go ahead and negotiate more money, but you're not entitled to it per the contract like you are regarding time. There is an exception, however, and that exception is acceleration. And what I've got here on this slide is the actual physics equation for acceleration, for the change in velocity as a function of a change in time. And that same equation is basically the same when you accelerate a construction process. So if I'm going 50 miles an hour and in a minute I accelerated to 60, my change in velocity is 10 miles per 60 seconds squared. That's my acceleration. So if you're going a fixed speed on a construction project for a certain amount of time, and then over the next amount of time, you have to go more quickly than you were previously going, you're installing more units per day than you previously were, you have accelerated. And that's the first time a lawyer's probably ever given a high school physics lesson. But there's two types of acceleration in construction. There's directed and constructive. So directed is the owner is very clear, or the contractor, if they're talking to a sub, is very clear. I am telling you that you need to work more quickly on this project. Go faster. It's usually not that clear. Usually we have a constructive acceleration, and the elements of a constructive acceleration are: first, there is an excusable delay. This project is slowed down through no fault of the contractor. The contractor requests an extension. The owner says no and demands that the contract be done on time, that the construction is performed on time. And in order to conform to those demands, the contractor accelerates. Two sides of the same coin. One is active, one is passive. Either way, you've been delayed through no fault of your own, and you have to still meet the contractual completion deadline. This is how the courts put it. This is another Ohio case, and this Smoot case is an often cited Ohio case. Constructive acceleration occurs when a contractor has a justified claim for an extension of time, but is required to incur additional expense because the project owner refuses to grant the extension and requires the contractor to complete the project by the original completion date. I throw that in there just so that you know, courts, this is a thing. This isn't just a story that a lawyer made up to get through this presentation. This is a real cause of action that contractors bring to courts. The courts have looked at before, and they know how to deal with it. So what is an excusable delay? Is COVID-19 a force majeure / excusable delay? And there are a lot of reasons, good reasons, that we can argue, yes, of course it is. We've got quarantine interruptions, outbreak interruptions, cash flow interruptions, labor shortages, people getting sick, travel restrictions, supply chain issues, inefficiency. There are plenty of solid reasons to argue that COVID-19 and pandemics generally like this are force majeure issues. Again, however, it's important that you have a contract that includes pandemics. If you don't, we can deal with it, but it's better if you do. And as you just saw, the A201, the A101, a contract that we all have seen a million times, doesn't say pandemics. And in the Smoot case that we just looked at this definition from, same case, that was a case for a weather delay. It was not a pandemics delay case, because before March, there were no pandemics delay cases in America, at least not lately. This was a weather case. The contractor said, hey, there was a ridiculous amount of bad weather, force majeure, we need an extension of time, we need to not be liable for liquidated damages, we need to be paid for the additional costs associated with the delay. This paragraph number 2 that you see here highlighted or reproduced on the screen, this is the literal force majeure clause from the construction contract in Smoot. It says a force majeure is unforeseeable cause beyond the control and without the fault or negligence of the contractor, including acts of God, the public enemy, sponsor agency, omissions of another contractor, blah, 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 epidemics, quarantine restrictions. The SMOOT lawyers and builders actually have quarantine and epidemics in their contract. And people are, I guarantee you, are going to use this. And they're going to say, hey, contractors know how to cover themselves for this. Look at the SMOOT case. SMOOT case gets thrown around a lot. They're going to say this is a cornerstone of Ohio construction law. If they could have gotten it right, then you should have gotten it right too. Unfortunately, epidemics and quarantine didn't do the SMOOT folks any good at all because it wasn't an epidemics and quarantine case. It was a weather case. And the court found, yeah, you had bad weather, but you haven't proved to us how that bad weather slowed you down. Just giving us weather data showing that weather was worse than normal is one thing, and the fact that you fell behind on the project is another thing, but you failed to connect the dots. You didn't show us how one equaled the other. Apparently there must not have been expert opinions or something like that to tie the two up. And that's an important point to make in any force majeure type of situation, including COVID-19. Sure, you can talk about how this virus has impacted the entire world in a very negative way, and you can talk about how your work is slowed down and that there's a correlation, but it's important to find a way to connect those dots, and we'll talk about how to do that. The Boone-Coleman case here, won't read every word on this slide. Suffice it to say, the Boone-Coleman case relies on another well-documented construction case in Ohio, where the Ohio Supreme Court has, almost to a point of being anally retentive, will enforce a notice clause in a construction contract. What I mean by that is if a construction contract says you've got 21 days to submit your claim for a force majeure or any sort of extra related event that you don't believe is covered in your base contract, you've got 21 days to give your owner, your general contractor, notice of that claim. And if you don't meet that deadline, you waive your right to make that claim forever. Ohio is hard on the construction industry when it comes to notice. So be very wary of your notice clauses. We'll talk more about what those look like and how to deal with them as we go forward here. Also, it bears mentioning that there is a Fairness in Construction Act in Ohio. I'm not going to get into the details of that, but if you're wondering about it, and some of you may be, there is an act that says it is against Ohio law for a contract to say that a contractor isn't entitled to extra money if the owner delays the project. And the same is true if a general contractor delays the project. They have liability to the subcontractor, not just for extra time, but for extra money. And even if there's a clause in a construction contract that says you have waived your right to ask for extra money for a delay, even if the owner caused it, that clause is void in Ohio. It will not be enforced. What an owner is going to say back to a fairness in construction type of argument, though, is, hey, we didn't cause this delay. Act of God, force majeure. This one's nobody's fault. Maybe they're right, but maybe they're not. What if they made it worse? What if they could have taken steps to deal with the pandemic a lot better, such that the project wasn't shut down or wasn't delayed the way it was? So there might be ways to still use the Fairness in Construction Act, but there are defenses to it as well. So a delay recap: negotiate a specific force majeure clause, one that's got a reference specifically to pandemics in it. Document your delays thoroughly. We'll talk more about that. Provide contractual notice. Before we talk about documentation and notice, though, I want to talk quickly about termination. Again, remember, those are the two most major foreseeable consequences of force majeure: project delay, contract termination. So before we get into the claims process, let's take a quick look at what the A101 and A201 say about termination. Again, the A101 just kicks you over to the A201. A201 says that a contractor can terminate a construction contract if the project is stopped for a period of 30 days for any one of these four reasons. Three of them bear relevant to a pandemic. One is issuance of an order of a court or other public authority that requires work to be stopped. So if the governor of Ohio says construction shuts down and it stays shut down for 30 months, per 14.1.1, you have the right to terminate that contract. Two, an act of the government, such as a declaration of national emergency. Again, We've seen that happen. Or 4, the owner has failed to furnish the contractor reasonable evidence as required by section 2.2. We'll take a look at that a little bit more at the end. That is evidence that the owner can actually continue to afford building this project. More on that in a second. The first 2 now, though, if your project is shut down for 30 days because of a national emergency or a governor or a president's or a court's order that says we're shutting you down, per 30, you have the option to terminate that contract. Think carefully before you ever terminate a construction contract. It's almost never a good idea. I don't care how clear the contract is. You're going to find yourself in a lawsuit. But if you're concerned and you feel like you need to go there, you've got some strength behind you in 14.1.1. The owner can terminate for cause for any of these 4 reasons, again, 3 of which are relevant. The contractor refuses or fails to supply enough labor. What if you tell the owner or the general contractor, I'm not sending my people to your project, it's not safe? They may try to use 14.2.1.1 against you and say, I have demanded you get your people back out here, you haven't done it, I'm terminating. Not the most sentimental and maybe not the most provident decision, but owners and contractors aren't always the most sentimental and provident folks. So it's a thing that you might see or have to deal with. 3 is repeated disregards of applicable law, statutes, or ordinances. This could be the flip side of things. You could have an owner throw you off because you're coming to a project that you shouldn't be coming to because of a court order. Or 4, you're otherwise guilty of substantial breach of the contract. That's a general catch-all that they can just throw whatever they want at you, basically. Again, courts don't favor the broad versus the specific, but they're always in there anyway, just in case. Also, a thing that's fairly unique to the construction industry is an owner can terminate for convenience at any time without cause. Other industries, there are a lot more repercussions for terminating a contract. In construction, however, there is leniency. If an owner terminates your contract, you are entitled to some remedy, but they're defined in your contract. The general tack that most owners take and that the A201 take is that you get paid for the work you've performed in place, and that's it. Recognizing, however, that you're going to take a loss, a provident contractor will include a termination fee. You know, you'll pay us for the amount in place plus 10% of that amount for the cost of having been damaged by this convenient termination that you've decided to pursue. And in this type of situation, we saw it in 2008 when the economy tanked. There were plenty of buildings that were sitting around half completed because the owner just pulled the plug on them. Terminate for convenience. It's less expensive than going forward. So I'm down on the 3rd tier now of my hierarchy of where I want to be contractually. I don't have a specific force majeure clause. I don't even have a general force majeure clause. But nonetheless, I have been impacted by this pandemic. What's left? Is there anything left I can argue? Yes. There's 3 things that you can argue: impossibility, impracticality, and frustration and purpose. Impossible just means I physically cannot do it. This can't be done anymore. We can't get the material. We can't get the people. It's not just super hard. It is literally impossible for us to perform this contract now. Impracticability is a stitch less than impossible. Yeah, I guess if we moved heaven and earth, we could get it done, but let's be realistic. We're not going to do that. That's impracticability. And frustration of purposes, it doesn't even make sense to continue with this project anymore. You were building an amusement park and people can't go to amusement parks anymore. There's no point in continuing this. These are arguments that have some legs and give you, it pays your price of admission to the rodeo and you get to ride the bull. But you are in a lot better position if you have a clear contract. Hopefully one that says pandemic, but one that at least anticipates force majeure type events. But if you don't, all hope is not lost. There are these other remedies. So keep them in mind. Now we're going to talk about making claims under the contract. It's not as hard as it sounds. A lot of people get the claims process wrong. And with just a few quick guidelines, I can show you, hopefully, how to get it right. First of all, again, notice is critical. This is from the A201. The A201 says, get notice within 21 days of the occurrence of the event giving rise. So if, tomorrow there is an outbreak on your job site and your people have to leave for an amount of time, send that notice as soon as possible. Don't wait 21 days if you don't have to, but definitely get it in within 21 days. Remember, notice is a two-way street. Solicit information, even if they're not forthcoming automatically with it, from the folks who are down the contractual food chain from you. So if you're a contractor, talk to your subs. Hey, are you going to have labor issues? Are you going to have supply chain issues? How are we doing here? Because if your subcontractors come out of the blue 22 days after what might be called the day you should have known something happened, it could be a problem for you, right? The owner may say to you, you should have talked to your subcontractors before now. Your 21 days are gone. So talk to your subs, talk to your owner, much communication as possible in this type of situation. Other tips, do it in writing. Things that happen verbally, or people have forgetful, inconvenient memories, do it in writing. One of the things that I tell my students repeatedly and my clients repeatedly, one of the best things that you can do if you have had a verbal conversation with somebody about something that is very important. You've been told by an owner or a contractor, hey, accelerate your work, track your extra costs, we'll square up at the end, we'll do it time and material, just get this done. You have that conversation. Maybe nobody was there to witness it. Maybe somebody was. In either case, email can be a terrible thing. Email can be a beautiful thing. In this case, it's a beautiful thing. You go back to your office, you write up an email, you put a marketing spin on it, you make it sound, cooperative, and you say, hey, great seeing you at the project site today. Per our conversation, I understand that you want me to accelerate the project, track my time, and submit a change order at the end. Please let me know if I've misunderstood. 9 out of 10 times, you're not going to get a reply to that. That's okay. At the end of that project, when it's time for you to square up and you collect all your time and material evidence and you submit it and they say, what is this? I never told you that. You forward them that email and you say, hey, remember this? I asked you about it 6 months ago and you didn't object then. That is just in the boardroom type of situation. It's great in court, but even in a boardroom situation, that's a lot harder to look at and deny versus, well, we never had that conversation. I never said that. So close the loop if you can. If they don't reply to you, maybe send a follow-up email or two just to try to get them to comply. If they don't, it's fine, but even better if they do. Mind your meeting minutes and daily reports, but don't count on them. So maybe you get in the meeting minutes that says, yeah, here's a change order. Your meeting minutes do not count as notice. The courts have already weighed in on that, either your daily reports. Actual notice is required. And a lot of contracts, or at least some contracts, are very specific about what notice means. You have to give notice to a particular person by a particular means. So it may say, in order for me to provide proper notice of a force majeure type of event, I have to send a certified letter to the project executive at this address. So that means that's the only thing that counts as notice. If you tell the job site superintendent, even if you hand him a ticket or her a ticket that says, here's my notice, that's not notice per the contract. Figure out the proper way to give notice and do it on time. And you have to continue performing. Everybody already probably knows that, but the A201 requires you to keep working on that project while you try to negotiate that claim. 15.1.5 just basically says follow the notice requirement in 15.1.3. It expects you to get to give that notice before proceeding with the work. It's just kind of a double down on 15.1.3, and 1.6 is the same thing on time. If you expect to be given extra time, give notice pursuant to this clause. So follow the contract requirements. Take tons of photographs. Photographs are great, general ones and issue-specific ones. Establish a separate cost accounting for your COVID-19 related claims. Don't lump them in with your general cost accounting. You want to be able to capture them separately so that you're not trying to pull apart, a grilled cheese sandwich at the end of the day and say, this part of my costs is COVID-19 and this part is general. If you just track them separately all along, it's much cleaner. Identify your extra expenses, including extended general conditions. So if you're going to be running that job trailer longer, foresee that, account for it, include as much as you can in your notice before you actually incur the costs. So some quick tips on human resources going forward. We've got two main issues. The most important issue, of course, is employee safety and job site safety. We want to make sure people stay healthy. But we also, while we're doing it, want to minimize our own liability. And the first case that I've seen, at least, to come out about a wrongful death type of situation where there was an outbreak at a Walmart and several employees died of the virus. There is now a lawsuit pending, Tony Evans versus Walmart, and it alleges that Walmart failed to do all of these things that you see here. It's a lot of things. I broke my own rule about too many bullet points on a slide, but I did it to prove a point. In this case, the survivors of the plaintiff's of the deceased plaintiff's claim that Walmart failed to do all those things, and you can read them: clean and sterilize the store, enforce social distancing, provide PPE, warn employees, follow safety guidelines, on and on and on and on. You can read all of those things that they allege Walmart failed to do. Now, no plan is 100% foolproof. You cannot guarantee that the virus isn't going to infect your office, infect your job site, and if it does, litigation may ensue, and there may not be anything that you can do about that. But if it does, you want to position your company to be in the best place to respond to that. You want to demonstrate to the court and to the world that you have done everything a responsible and reasonable company would have done to prevent these things. We did clean and sterilize. We did enforce social distancing. We did provide masks. We did follow the OSHA and CDC guidelines. We did everything we possibly could. And that person still got sick, and it's unfortunate, but there was nothing more we could do. That is a much better, and I don't know that Walmart really didn't do these things. These are allegations. I'm sure Walmart's going to come back and say these things are totally false. These cases are literally just baby cases. They've just been born. We don't know where they're going, but we do know what's alleged, and this is what it looks like. So this can be a checklist of things that your company can do to try to make sure it has done everything practical it can do to avoid liability going on. Also, workers' comp. Nobody knows how that's going to play out yet. Are these claims covered by workers' comp? You know, if they're truly job site injuries that are sustained accidentally while at work, sounds a lot like a workers' comp claim. To be continued. We don't know. Also, these folks have the burden of proving that they got the virus from work. That's hard to do. It's easier to do if there are 10 of you that all worked at the same place and got it. But you could have gotten it if you all lived in the same neighborhood or went to the same church or whatever the case. It's a difficult burden to meet. Other things that you can do, identify essential tasks and send everybody else home. Consider alternative work solutions, implement safety policies, and increase cleaning and maintenance. On the project site, it's important to communicate with everybody, your subs and your owners, review the contracts, make sure the site's secured, maintain skeleton crews where possible, identify work that's an emergency that's got to get done no matter what, keep everybody in the loop, and take lots of pictures. For your subs, you can verify that they have project access. You can incorporate guidelines into your contracts. You can clarify again what work is an emergency. And if there's going to be a delay, you can clarify that or have them clarify it to you as well. OSHA's got some great best practices at that link there, which you can click on at your leisure. Provide additional PPE and sanitation supplies. Think about amending your safety policies, additional training, and even some COVID-19 related job site safety talks. All could A, prevent the spread, and B, cover your liability in the unfortunate event that there is an outbreak. Quick comment on insurance. The first case to come out that is getting a ton of press is called CAJUN CONTI versus certain underwriters at Lloyd's. This is a big fancy restaurant down in New Orleans. They had to close because of the virus, and they filed a claim against their insurer under their business interruption insurance. And they said, hey, our business is interrupted. This is why we have this policy. You have to pay us for it. And they didn't even wait for the insurer to deny coverage. They literally filed a lawsuit asking the court to make a preemptive decision whether or not their policy covers business interruption. I read a very compelling article, however, from an insurance professional who looked at this from the insurer's perspective. They made a strong point that they were not a lawyer. They were a professional claims adjuster, and this is the problem with the business interruption insurance claims. First of all, there's a pollution exclusion. This author admitted that that wasn't the best argument in the world, but to the extent this is considered pollution, if there's a pollution exclusion, it may apply. Some of the more compelling arguments, though, is in order to trigger your business interruption insurance, there has to be a physical loss or damage to the property. And there's an argument, a colorable argument, that this pandemic is not a physical loss. It can be wiped clean with a Clorox wipe. As a matter of fact, it self-destructs on its own. I guess that's what self-destruct means, if left alone for 72 hours. Without physical damage, your business interruption isn't covered. Also, another potential defense is that preventative measures aren't covered. So if you're expecting a hurricane and you put boards up on your windows, you don't get paid back for the cost of putting those boards up. That's a preventative measure. If a hurricane comes through and blows your windows out and you hire a contractor to board up the empty holes, that is covered because it's an actual loss. As goofy as that sounds, it's a thing. And there is an argument that closing your business is not the cause, is not the effect, it's the cause. This is a preventative maintenance that you undertook so that you wouldn't get all the claims that would be associated with spreading infection. It's a preventative measure and it's not covered. Again, we don't know how these are going to play out. We're still waiting to see. The takeaways is to review your policy, see what it says, mind the exclusion or acts of God excluded or pollution excluded. Again, notice. Even if they ultimately reject your claim, the earlier you give your insurer notice, the better. Better your chances of not getting rejection. Document your issues with suppliers and vendors as you try to pursue this claim. Track all your receipts so that if they are going to honor the claim, you can actually prove what your losses are. And 2 more quick slides. I alluded to this earlier. The A201 and most sophisticated commercial construction contracts provide you the right to review the owner's financials if you are concerned that they are not liquid or solvent enough to go forward with the project. You can demand that. Prove to me that you have the funds available to finish this or I walk. You can do that. It's in the contract. And then lastly, don't forget about all of the tools that you have available to you with regard to pursuing payment, pay when paid clauses, the fairness in construction rack, lien waivers, notices of commencement. We've got some more seminars coming up with ACI regarding potentially some of these things, and we can talk about those in further detail. I just want you to know, that there are ways to be aggressive about collections out there, and the overarching theme of this slide is now more than ever, it is important to be aggressive about collections and use the tools that you have. So I'm about 3 minutes overdue. I apologize for that. I have all the time in the world here if anybody wants to hang out and chat questions. Otherwise, I thank you for your time and your attendance, and good luck and stay safe out there.